interpretation of the statute in whole that we can get to that.
The only cases that define in his presence and within his immediate knowledge that they are synonymous are the misdemeanor cases, the first sentence cases. There are no second sentence cases that define that. I'm just pointing that out.
You know, I say the first and second sentence thing that we're talking about is one reason why I think the citizen's arrest statute was a mess before it got changed. It's the mess that we are living with, but those two sentences are applying to two different scenarios, and it just wasn't ever real clear until you read every single case ever reported on those statutes. And then you see the pattern develop that, as Mr. Rubin just said, all of these presence and immediate knowledge cases are usually misdemeanor shopkeeper cases. And then there's very few cases involving fleeing felons, very few.
I understand that.
In the few cases previously, felony cases previously cited to the court, the presence and immediate knowledge requirement obviously did not and could not apply.
Let's get past where we are. I understand the defense then takes exception to what is going to be charged, but I've explained what's going to be charged.
Thank you, Judge.
I want to say the defense, both the McMichael's defendants and the Bryan defendant. Okay.
All right, so next one is must make the arrest contemporaneously, and that is the state's position. The state is basing that on McWilliams versus Interstate Bakeries Incorporated, 439 F. 2nd 16, a 1971 case, but out of the state of Georgia. And what we have here is we have a guy who goes into the bakeries and does indecent exposure, and a woman sees it. He shows up 4 days later, and she's like, there he is! And they arrest him and detain him for the indecent exposure 4 days beforehand. He then filed suit saying, you know, they falsely imprisoned me because you can't do a citizen's arrest. It's for exigent circumstances. It's for the emergency. It's for the immediacy. If you've got an issue, you know, call the police, have them do the investigation. They take out a warrant. They do what they're supposed to do. And that's basically what Interstate Bakeries said. A private citizen's warrantless arrest must occur immediately after the perpetration of the offense. If the observer fails to make the arrest immediately after the commission of the offense, his power to do so is extinguished, and a subsequent arrest later is illegal. I threw in the word later. That's not actually in the charge. And a subsequent arrest is illegal. And that is actually what we're asking for, because that's what the case law says in McWilliams versus Interstate Bakeries. I believe the defense is going to argue, well, that was a misdemeanor case. It's indecent exposure. So that only applies to the misdemeanor. But here's the problem. If the offense is a felony, meaning the one you just saw is a felony, and the person's escaping, then on probable suspicion, you can go ahead and arrest them. So I'm trying to come up with a really good illustration of a factual basis. Does the court even want me to try and do that right now? Nope? Okay, I won't. I'll just say we would like this state's request to charge number 55, which is must make the arrest contemporaneously.
Your Honor, McWilliams versus Interstate Bakeries is clearly limited to misdemeanor offenses. It is merged with Adams versus Carlisle, which is really the footnote that the state is citing out of McWilliams. And in that instance, the holding is a private person can only arrest for misdemeanor offense when that offense occurs in his presence. Then the arrest must occur immediately after the perpetration of the offense. So it's not applicable to the case at bar.
It's a first sentence.
The state disagrees with this first sentence, second sentence distinction that they're making. The first sentence applies to misdemeanors and felonies. The only time the second sentence applies is when someone's escaping. You have to also be escaping. So the first sentence does apply to misdemeanors, and it applies to felonies. And I think Mr. Hogue even stated that and made that very, very clear. So this weird distinction where it only applies to misdemeanors, that is not at all true. You have to, if it's a felony and the person's escaping, then you get to do these other things. Then you can go ahead and chase them down. You can't chase down necessarily someone who's committed a misdemeanor, but you can chase somebody down if they're escaping. So that's really the distinction here between the first sentence and the second sentence. Not that the first sentence is only on misdemeanors. It's misdemeanors and felonies. The second part applies when you're escaping. So I just want that distinction to be made. And here in McWilliams, there was no escaping. And it doesn't matter whether it's a misdemeanor, because the first sentence, immediate presence, if you don't arrest the person who's committed the felony right there and then in front of you, your ability to arrest him later is extinguished. And here's the thing. If the guy's pumping gas, you notice how Mr. Hogue said, well, if he's pumping gas and you go up and say, hey, you're the guy from the other day, and the guy runs off, all of a sudden he's escaping from something he did 4 days earlier because you've confronted him. How many minutes of how many days is he escaping? So it begs that question, and I think we're all going to be arguing that, but we ask that this, which is good law, be given to the jury because it applies to both felonies and misdemeanors, because the second sentence only applies under certain circumstances.
But it is, as I understand it, though, this entire case is the question of chasing for the purpose of detaining for an arrest. So the question of whether or not it's a misdemeanor or a felony and morphing them all together is just not accurate for the jury and in their assessment. Otherwise, we would not have two sentences in this statute.
If I could just I'm sorry, Kelly.
Oh.
You wouldn't need the second sentence, reasonable and probable grounds of suspicion, if it occurs in your presence or immediate knowledge. You have probable cause if it occurs in your presence. The reason there is a second sentence is because when it's a felony and the person's attempting to escape, there's a lesser burden. It doesn't have to be in your presence or immediate knowledge. You have to have probable cause. And probable cause does not require presence or immediate knowledge. Police officers get warrants for with probable cause for events that occurred days earlier, weeks earlier. They get arrest warrants and search warrants under those circumstances. It would render the second sentence superfluous if the definition is as stated by the state.
Your Honor, I don't know, I guess it's the opposite of flattery, because, I filed stuff on this a long time ago, and it seems like, as Ms. Dunikowski's standing here, she had read it. Your Honor, we're conflating two different issues here. The fleeing felon part, Ms. Dunikowski makes a valid point. You can't go back a year later when someone's sleeping in their house and arrest them as a fleeing felon. There has to be some flight. And just because you have probable cause to believe someone committed a felony doesn't mean you can arrest them. But in this case, if there isn't a fleeing felon in this case, then there never could be. This is the very definition of a fleeing felon. It doesn't have to be fleeing immediately after the crime, but he's fleeing nonetheless. And what Ms. Dunikowski is trying to do here, I may take that back. I should not say what she's trying to do. That's not fair. What her argument is trying to do is conflate the issues on the first and second sentence with whether they're escaping or not. Escape has nothing to do with the first sentence, which respectfully has nothing to do with this case. The escaping part has to do with the felony arrest. Doesn't mean that the felony has to have taken place right then, that the person is escaping then. It means that there has to be an exigent circumstance, which is what the court has already adopted, that part of the language, and the